Guys, the Queen on the application of medical justice and the Secretary of State for the Home Department and another, followed by the Queen on the application of FB Afghanistan and the Secretary of State for the Home Department.
Yes, Miss Nike.
Please, Your Lordships. I appear on behalf of the first appellant FD with Mr Goodman and Mr Bandagani, instructed by Duncan Lewis. Learned friend Miss Kilroy QC, with Miss Hiccup and Mr Vaughan, instructed by Public Law Project and Peer Medical Justice. A learned friend Mr Kovacs QC and Miss Reed QC and Mr Toman, peer for the Secretary of State, instructed by the Government Legal Department. And the intervener, who was not present in court but has made written submissions, is represented by Miss Harrison QC and Miss Liu. So, my lords, I think you have all those parts.
Yes, I'm not sure I've got them on a bit of paper in front of me, but it's okay. I think everyone is reasonably familiar to us.
Indeed.
And are you're all sufficiently spread out to feel entirely comfortable, I hope?
My lords, we are. We're very grateful for the court accommodating us in person in the case of this nature. I think all counsel agreed that it's a better way to proceed if safe, and we're happy.
Yes, well, speaking for myself only, coping with quite so many thousands of pages of documents as we have in these appeals on screens would probably have defeated me.
Yes.
Although
endless headaches, yeah.
I suspect, Miss Knight, that we probably won't be looking at very many of those thousands of pages of documents, but
certainly in
let's see.
Yes, well, certainly in our appeal we hope to be able to cut a swathe through some of that material and get to the core issues.
Yes.
Can I just confirm the bundle situation and the skeletons to make sure that the court actually has what we hope the court has? So for FB, there should be a core bundle.
Yes.
And two supplementary bundles, parts 1 and 2, so one supplementary bundle and two binders. And then for medical justice, similarly, a core bundle and then two supplementary bundles in two binders.
And then 4 bundles of authorities, but quite a lot has appeared on the bench this morning.
Yes, so can I just take one through that? So critically, certainly for our purposes, the core authorities bundle is volume 1, and then there are 3 further volumes.
Yes.
So I'm hoping that the court can have the core bundle handy.
Of authorities.
Of authorities.
Right. So you want us to put something in it, do you?
So what was handed up this morning by Medical Justice and Defence there should be an amended index, and then
For which bundle?
the amended index is just for the core bundle. It's for the entirety of the bundles actually. So that the new inserts go behind tab 1, which is section 3A of the immigration.
Right. I'm afraid it may be that some of this may already have gone in. I certainly put 1 or 2 bits in myself, and my clerk has done some. So what I have is, I think, possibly a new version of the pre-reading.
Yes, that was for medical justice.
All right, well, that'll have to go in later. Then I've got an addendum bundle from you, I think.
That's from both parties, just dealing with the respondent's notice and what's happened since the bundles were lodged. So the respondent's notice, the response to the respondent's notice, and the letters to the court, the orders from Justice Hickinbottom, and our replies, the 2 replies which were sent in as directed yesterday.
This is all on the charter.
On the charter, so it all goes to the.
Yeah.
So we don't need to look at this bundle because we say it all goes to relief, and I think we'll all agree with
All right. Well, rather than take time now, let's make progress.
Yes.
We obviously have benefited from the extremely full skeleton arguments that have been lodged in this case, with my Lord's leave, by all the parties, and the result is that we would be extremely disappointed if between you were not able to complete the submissions in this case in 2 days. 3 days seems to us to be rather more than is likely to be necessary.
I certainly anticipated that once the pre-reading had been done, we might be able to cut quite through it. For my part, so the original timetable allowed me to proceed after lunch. For my part, if I may, try to complete by lunchtime, but just with the proviso that if there's something that my team over lunch tell me I should
Well, let's see how we go.
then I will just try to deal with that after lunch, and then we'll see where we are. Obviously, I think perhaps some of the significant time for the appellants may need to come and reply, and that's perhaps where we'd like to preserve our
We shall see.
time in the timetable. Thank you, my lord. So, as you can see from our skeleton argument, the core question is the lawfulness of the notice of removal window policy, which allows the Secretary of State to remove foreign nationals by notifying them of liability to removal within a time limited by the window during which to make their representation, but withholding any further notice of actual date and time of removal. So permitting removal without further notice following rejection of any further submissions. And we say this is a marked material change from the position as it was operating before the new policy, which effectively came in 2015. And again, critically, we say that, and importantly, the Tribunal found that the change in the policy wasn't justified by a change in the 1999 Immigration Act. So that I'll come to develop that point in due course. But the Secretary of State's position and the way the Tribunal interpreted it was simply that this is a policy provision that she is entitled to implement, and the Tribunal's position was that the 1999 Act didn't authorise that expressly. So it's going to become quite important to examine the statutory framework in relation to removals in order to determine both whether the policy conflicts with the requirement to give notice and reasonable notice, and the question of the vagaries of the policy. I just pause by saying, as far as I can look back in the Immigration Act, there's always been a requirement to give removal directions for persons going to be removed from the UK, going back to the Immigration Act 1971, which is at paragraph 8 of Schedule 2. You don't have to turn it up, obviously, at this point. So, excuse me, my lord, I just have to, if I'm going to drink water, I'm afraid I'm going to have to drink it out of the bottle.
Please don't worry about
we
that.
We don't have any glasses in court.
No, but that's for reasons of safety.
So, it's not my usual practice to drink that way. Sorry. And so we'll have to, so we say it's necessary to consider the statutory framework for the making and the setting of removal directions, the claim justification for the policy, and then the implications for the individuals affected. And later on, we're going to come back and look at, my Lord Justice Hickinbottom recently reviewed the relevant authorities on systemic unfairness in the context of Woolcock. So we won't need to go probably to those authorities in any great depth, but we will need to look at the principles which are in the skeleton argument and see how they apply in the context of this policy. When coming to examine the policy, just to be clear, because it's quite a dense policy to read when we come to look at it in due course, but we say the issue is whether the formulation of the policy is inherently liable to expose a person to a more than minimal risk of unfairness and or breach a person's fundamental right of access to justice, in particular by precluding them from effectively appealing or challenging the judicial review against following any unlawful decision of protection. So of course there may be lawful decisions in that time, but we're focusing on the risk.
So that your legal test is the policy inherently liable to expose to more than minimal risk of unfairness.
And what we say in practice following the authorities, and I will come to those in perhaps further on, is that we say this means in practice more than de minimis. So when we're looking at a policy that is concerned with international protection and the absolute obligation of non-refoulement or a breach of Article 3, that informs the way in which one evaluates that question of risk. So the Secretary of State is inviting a different approach, and she's saying no system can be risk-free. She's that there needs to be a legally significant number of cases. And importantly, as you see in her skeleton argument, she says, on occasion, caseworkers will make mistakes, but that's regrettable. That's just part of the system you have to live with. Now that is what we take issue with at the central part of our submissions, which is that if the system operates in a way that creates such a risk, that there will be decisions which are unlawful, which can't be capable of being challenged, then that renders this formulation of the policy unlawful. And I will come at the end of our submissions. The Secretary of State criticises both appellants, I think, for saying you haven't offered us a workable solution. But actually what we say, in short, in relation to a workable solution, is that following the Justice Walker injunction, what we have effectively is reverted back to the position as it was before the policy, so that persons are given notice of removal at 72 hours. And that, at a minimum, we say, is what is required, actual notice of actual removal. And so, in fact, we take objection to the Secretary of State's position, which is that we haven't offered a workable solution. Not that it's our job to offer workable solutions, but the court, of course, will be concerned to want to think about how it might operate in practice in the context of the various issues raised.
But you say that policy is fine and lawful.
But we say, at this time, at the moment, we have removal without notice, which is the focus of our challenge. For these proceedings, what we say is that a minimum is that 72 hours notice of actual removal must be given.
No, I understand that,
Yes.
but you say that would be lawful.
We say that would be lawful. Not to say that that's what we contend is necessarily required in all cases, and indeed we'll come on to look at what might be required in certain types of cases. But that would maintain the status quo, maintain the position as it was in 2010 and 2011 after medical justice, Mr. Justice Silver and the Court of Appeal, and not allow for removals of persons from the UK without them being notified of their actual removal. So what we inherently say is that the act of removing, as opposed to being notified that you're liable to be removed, changes the character. It changes the legal obligations the Secretary of State has to an individual, internationally and domestically, domestic obligations. And of course, it directly impacts on their human dignity. They're right to really know what the state is doing to them. It's akin, we say, to being detained without being given. We looked at in Lumber, Lord Dyson was referred specifically to persons who are being detained in pursuance of an unlawful policy. Use the Anna Friedlander principle to conclude that that such a policy was unlawful because the individual had the right to know what decision was being taken, so that they could have the opportunity to challenge it using Anna Friedlander. So it's for those reasons that we say that there is the individual's right to notice of a decision to remove them rather than just deemed liability arises here. So this is the obligation to notice. So what we say is that the notice of removal window is not notice of a kind that sort of satisfies the obligation. So you'll recall that the Tribunal.
So just which obligation and how does it arise?
Sorry, the notice of removal window, which is you have 3 days
Yes.
in which to bring your claim and after which you may be removed. does not, we say, satisfy the obligation on the Secretary of State to notify a person of an operative act which changes their legal status. Once the person, largely for the purpose of protection claims anyway, once the person has been removed from the UK, the Secretary of State doesn't owe them those international obligations. So the operative determining legal act is the act of removal, not the act of notification that you're liable for removal.
And the obligation arises, that's what,
Well, so,
under
I'm so
the
sorry, my lord.
statute
So
or?
we say that there's a series of obligations under the Human Rights Act, under the Refugee Convention, under the EU Charter, and under the Qualification Directive and the Procedures Directive. I'm talking more about protection claims, and I've confined my submissions to that.
Yes, I see.
Ms. Kilmore,
Because that's the obligation not to remove in the event that it would
could create a real risk.
put somebody at real risk. So, but you said, I don't mean to be difficult, but
Yes.
you've identified it as an obligation on the Secretary of State to notify, and I'm just
Oh yes.
keen to understand where that obligation arises as a matter of
My
law.
lord, so my lord, we say it's an obligation in order for the state not to be risking breaching its obligations under the Refugee Convention, the ECHR, and the Qualification Directive to give international protection to persons who seek it. We say that in order for that person to have access to an effective remedy, that they need to have notice of when they're actually going to be removed, so that they can bring the claim and seek that remedy if required. And that's what we say is the nature of the obligation under the Human Rights Act. And you'll see that it's also contained within the immigration rules themselves. So Rule 353A, which we'll come to in due course, prevents the removal of a person who has a claim pending. Similarly, Section 77 of the 2000 Nationality, Immigration and Asylum Act 2002 prevents the removal of someone who has a claim pending. But we say that if one looks at the way of the operation of the statute together with this policy, with risks in practice, a person who brings a claim is notified of their liability to removal, but then is not notified of the decision before the window comes to an end, before the notice period comes to an end. So thereafter they can be removed without notice, notwithstanding the fact that they actually don't have the decision on the claim that they brought, which is suspensive in domestic and international terms of their removal. It's quite a departure from the way in which traditionally, for decades really, the system has operated. And so that's why there's perhaps such a detailed amount of material before the court. But it does come back to those fairly simple and core principles. What we also, so that's the first part of that. And the second part of the principle, we say, as we set out in paragraph 3 of our skeleton argument, is that the reason that we say that the policy falls short of supplying notice of the kind or quality which is required in order to give effect to those rights which are to be able to seek an effective remedy prior to removal, is that there is, as we understand it, or there are directions that are set for removal, but the policy expressly conceals them from the person who's going to be removed. That's how we understand the policy. The Secretary of State can tell me if I've got that wrong. But that is how we understand it. And so the framework of the 1971 Act and the Immigration Act 1999 still refers consistently throughout it, and the 2016 Act, and I'll take those provisions in due course, but consistently throughout the statutory framework of immigration in the 71 Act, 99 Act, 2016 Act, is reference to removal directions. So it's not that there is that those provisions have been taken away. Those directions are still given to the carrier of the flight, as it usually is, in relation to removal. It is just that they are withheld from the person who's being removed.
Where does the obligation to tell the person that is removed, where does the obligation arise?
Well, we say that's the Anna Frieva obligation, so it doesn't arise on primary legislation that you must be notified. It arises by applying the principle of public law, which is when you have a decision to remove a person from the UK, that there's a public law duty in Anna Frieva terms to notify them of that.
That is, to, as I understand it, to prevent procedural unfairness.
That is, well, to present to procedural unfairness to have the right to an effective remedy. But when we come to look at Anna Frieva, Lord Staines's concern was that because of the nature and quality of the decision, insofar as and how it affected the individual, and in that case, my lords will recall, it was the refusal of an asylum claim which had an impact on the person's benefits, but they weren't notified about it. So Lord Staines's position was, if you have such a fundamental decision as the refusal of asylum, it's not communicated to you, but communicated to a third party which has a direct impact on your status, that then it is an unlawful decision unless or until it's notified. And so that principle in Anna Frieva, it's a long-standing principle of public law. That's what Lord Staines emphasises, is how public law should operate. And so, and as I said, and this is important when we come to look at the scheme, that notification was always previously given. The Secretary of State, in her skeleton argument before the Tribunal, and I think before this court, seems to suggest that the amendments to the statutory scheme under Section 10 as to removal, so the Section 10 of the 99 Act amended by Section 1 of the 2014 Immigration Act, we'll come to look at these, but the Secretary of State's case is that that allowed her to remove without notice. But the upper tribunal rejected that argument expressly by saying it isn't there's no change in the statutory scheme that authorises that. Secretary of State doesn't cross-appeal that point. So it's when we come to look at the judgment, it's at paragraph 155 of the upper tribunal. Because, and we'll come to look at the way that's structured. But once that's a core part of our case. Once the Secretary of State's statutory justification is taken away, then the court is looking at the evaluation of the policy through that lens, in terms of whether it's consistent with international obligations and the requirement to give notice, looking at Anna Frieva. Just in short, and I'll come back to my how the policy operates in fact, but just coming back to the Anna Frieva point. In short, the upper tribunal said that Anna Frieva wasn't what they described as remotely analogous to the situation here, and we'll come on to develop why we say it is entirely consistent principle and binding principle on both that tribunal and this court as to the requirement to give notice. And so I hope that answers my Lord's question in relation to where does the requirement to give notice come from, and that's where we say very clearly it comes from. Again, the second point, I'll just at paragraph 3.1 of the skeleton argument. But the second point is that fundamental to an understanding of how the policy operates is that it doesn't provide for 72-hour notice period of a crystallised intention and decision to remove. And it's critically important to understand that the nature and quality of what is being notified. And what's being notified is, in the ordinary case, within the next 3 months, you may be removed without notice. And the only things that may prevent your removal are a series of potentially discretionary decisions by the Secretary of State in response to the representations that you make. But you won't have any notice of those decisions before your removal necessarily. Now you might do, but that just would be happenstance, not as of right. And that is the problem. The Secretary of State is not undertaking, in anywhere as I see it in reading the policy, to give a particular period or any period of notice on the policy of those further discretionary decisions. She's simply saying, I will remove you once I've taken a decision on those further outstanding representations. If I decide that they don't amount to a fresh claim, or you've made a previous claim in 6 months earlier, or whatever it is, then I will reject your submissions, and you'll be then you will be removed, and I won't give you any notice. And the
I'm sorry, just
Yeah.
to halt there. When the Secretary of State says this, the Secretary of State is going to give notice of the paragraph 353 decision.
No. This is why it's so, as I understand the operational policy, and this is the core part of our case, the Secretary of State is not going to give any notice of any discretionary decision outside of the 72-hour window, notice period, I'll call it the notice period. When that notice period comes to an end, she may give a decision saying I don't accept your claim, but it won't, there's no requirement for any period of notice to follow that decision.
No, I understand that. But where you say she may give a decision on the claim, that it's covered by paragraph 353, doesn't she always give a decision?
She will, she's right to say that she will always give a decision,
Yes.
but she won't give one with any specified period of notice.
No,
or
I
indeed any
understand
notice.
that. I understand
sorry,
that.
yeah.
No, I understand that. So these discretionary decisions that you've referred to,
Yeah.
she gives the decision to the individual in respect of those decisions. But your complaint is, after those decisions are made, she can then, under the policy, remove the next minute or the next day.
Indeed, and the point about those decisions is that there's no guarantee that they come within the notice period. So if the decision was to come in that 72-hour notice period, what the individual could do, although there may be a very short period of time in which to do so, but that's as it would be if you were notified in the status quo scenario. The individual could seek to bring a judicial review and get an injunction if they were unhappy with the adverse decision. But what they need is obviously time to do that. The Secretary of State's policy says that after the 72-hour period has expired, irrespective of whether you've got a decision on your fresh claim or outstanding representations, she can then remove you without notice. So that's the mischief of the policy, is that if you're in the removal window, so once the 72-hour notice period has expired, then the window is open for 3 months. In that period, she can give a new notice of decision in one hand and remove you the next. And that's what is, we say, totally incompatible with the anafree notice period, the international obligations under the ECHR, and the Refugee Convention, the Qualification Directive, Procedures, all of those things. Because what it denies is the opportunity to get a remedy. And so it's...
That would also be contrary to common law.
And the common... Well, we put it in terms in relation to unison, for example, as well as anafree. So what the Secretary of State will have to try to persuade the court of is that this is not, in fact, what is actually happening. But that is, in my submission, quite clearly what policy not only provides for, but what would have happened in relation to FB, and I'll come on to his facts just briefly in due course. But we say the effect of the policy is to reintroduce the zero notice removal, which was what was under challenge in medical justice in 2010, which the court found to be unlawful. And so, just as an illustration, so what we say of how this would work and how it works perhaps in FB's case, is that a person at the point they're served with the notice of removal window could either have outstanding representations that haven't been responded to, or, which is contrary to the way the Secretary of State puts it in her skeleton argument at paragraph 12, where she says that it's inevitably for people who have nothing outstanding. But that's not what the policy policy says it can be served for someone who has outstanding representation, as I understand it. What she does or it could be somebody, so for example in FB's case, she came to the UK and he voluntarily handed himself into the police station, was interviewed, indicated, restated he wanted to claim asylum, the Secretary of State said that's not clear, but within, either during that interview or within a day, he indicates he wants to claim asylum. The Secretary of State serves him with a notice of removal window, saying you could be with 72 hours, and after that you could be removed. But she also serves him, without notice, but she also serves him a notice, section 120 notice, which is what it's so called, which is an invitation to make further submissions, if he has anything he wants to say. So what she's doing on the one hand is saying, you've got 72 hours in which to bring a claim, here's a notice saying that you should bring a claim, and then I'm going to remove you from the UK after 72 hours, or you should regard yourself as being going to be removed within 72 hours. But what she doesn't do, and this is the problem with the core mischief of the policy, is guarantee that you get a decision within those 72 hours. And if you don't have the decision, the substantive response to the thing that you claim or say, you can't bring an effective challenge. And the only thing you could do in judicial, this is the logical consequence of the Secretary of State's position, is, well, if you could access the lawyer, I mean, bearing in mind that in this scenario in FB, we'll look at his facts briefly, but he was taken to a detention centre, he saw an advisor for half an hour in a detention surgery the following day. But if he had acted as the Secretary of State must intend, by the logical consequence of her policy, which is on the fourth day, 73 hours, after that 73 hours I can remove you without further notice, or I can give you a decision and then remove you. The only way that an individual will be able to seek access to the court is to preemptively seek an injunction. To go to the court, come to the administrative court, or the upper tribunal, and say, I want an injunction because I've said something to the Secretary of State, I haven't had a response yet, I say it's a protection claim, and by the way, as we know now that FB is in the asylum appellate system, he has got a protection claim, and it is going to be litigated before the first tier tribunal. So it would have been litigated already, but for the COVID closures, in fact. But so that's what we say is the logical consequence, is that in order to prevent removal, to get access to justice, this court will have to not reduce the number of emergency applications that come before the court when you don't have an actual decision, but actually come to the court and say, well, what we have is, we know that if we do as the tribunal required us to do, which is to treat the fourth day as the removal day, even though we haven't had a decision on the representations, which may be substantial as they were ultimately in FB's case, but he didn't bring them in the first 3 days, then in those circumstances you have to go to the court for injunctive relief preemptively, and that has a whole unworkable impact in relation to pressure on the individuals, the solicitors, the Secretary of State and the court, most importantly, and that's not anything that the appellants would contend for. If you have notice of actual removal, the actual decision that changes the legal obligations of the Secretary of State, then towards the individual, then that is the target decision for judicial review.
I understand that,
Yeah.
which is your first submission. I'm not convinced that submission helps you here. This is a completely different point, and it seems, to me, speaking entirely for myself, it's not a challenge to the concept of a window. It's a challenge to the policy in not giving sufficient time for an individual to access justice in relation to a material decision. But that's a different point.
My Lord,
For example,
yes.
if in your case, if in FB, as you've outlined it, there had not been a window, but a notice of removal,
Yeah.
the position would have been exactly the same. asylum claim would have gone in, and removal would have been effected, but for something to prevent it. There used to be under the old policy, I understand that.
In FB's case, it's right to say because he unusually had only just arrived in the UK, he returned to the UK, as you can see from the facts, having previously been here some 6 years earlier. But so in his case, and therefore he's treated as a fresh claim case, if he'd been served with a notice of removal, you require leave but you don't have it on the first day, then he would have known that he was going to be removed, and he would have to have sought a preemptive injunction, because he would be saying, I've got something I want to say and I haven't got a response to it yet. But the common scenario is somebody who's already made their representations and hasn't got a response, hasn't got a decision from the Secretary of State, or somebody who gets the notice of the removal window, is able to make the representations because they have a representative or someone on record, but is still not able, still hasn't got a decision from the Secretary of State and no guarantee of one before the removal, before the end of the notice period. And so the Secretary of State will then be able to serve the decision removed without notice. That is wholly new, and that's what we say offends the Anna-Frieda principle. And the reason we say there's a difference between the operation of policy as it was, i.e. give a notice of removal, versus give us notice of a removal window during which time we might make a decision, is that because the Secretary of State isn't guaranteeing to make a decision within the notice period. She may serve the decision within the window. It sort of comes down to relatively simple point. And if you use the analogy of an actual removal, what she'd be doing is saying, I'm going to give you the decision, but after you've been removed. If you treat day 4, 72 hours, as the time we've been, as the actual removal, rather than the time from which you may be removed, what it, in simple terms, is saying, I'm the Secretary of State, I'll give you a decision, but I won't give it to you until after you could be removed. And if could be removed means removed, then you have to get preemptive injunction. The Secretary of State knows that she's not going to breach her international obligations by removing somebody before she's responded to their representations, but you don't know, as the individual, when you're going to get that decision, so that you can bring a challenge if it's an appropriate thing to do. You can instruct your lawyer. That is the hard-edged mischief of the point. If the Secretary of State notified you that she was going to remove you on a particular date, she'd have to serve you the decision. And even if it was because you brought a relatively late claim, a few hours or even a day before the removal, you would have the opportunity to access the court. That's consistent with the Medical Justice 2010 position. But unless you have noticed, unless you know when the removal is going to be, that's the target, the operative change of status decision, which is what you come to the court, to the administrative court and say, I'm going to be removed and I wish to challenge that removal because I say my life is at risk in Afghanistan, as Mr. FB was saying. And that's what the target is. It comes to that point. The Secretary of State, if she was saying, either I will make the decision before the end of the 72 hours, which she's not, or she was saying, I will give you notice of removal in a certain period of time. I will make the decision within 72 hours of your removal, and here's the notice of your removal. Then there would be no problem with that. It's the lack of the notice of the removal decision, combined with the fact that the Secretary of State will inevitably, under her policy, make decisions without notice, which is the mischief of the policy. And you can't, absent getting a preemptive injunction in every single case at the end, so that to stop removal at the end of the 72 hours, and that would be, you can't address it in any other way. And we say that would be improper. Of course, you wouldn't want to come to the court seeking preemptive injunctive relief. Because realistically, what you wanted to is to evaluate the response to your representations then decide whether or not there is in fact a meritorious claim there. But there wouldn't be any alternative but for this preemptive strike, so to speak, because the only target is the end of the window. The end of the notice period, after which one might be removed. And so that's why we say that the policy is unlawful. That's how it works in practice. So there's a requirement to give notice. I see my Lord's point that there was a requirement to give notice, and the impact of the failure to give notice then impacts on the access to justice, because there is no opportunity, or potentially no opportunity, in which one may seek the recourse of the court in response to the adverse decision. Secretary of State, as I understand it, there's no answer to that in their skeleton argument. They simply say that you have to rely on the discretion of the Secretary of State. Those decisions are all discretionary. The Secretary of State will review them, and it's up to her. But if she gets it wrong, which brackets she might, regrettably, as the Secretary of State puts it, in international protection cases, then that's just part of the way the system has to operate.
Well, I'm not sure that Mr. Kovat's submissions are as you set them out.
I don't want to misstate them, but I do recall them.
Because I think he says that there's quite a lot that can be done. But in that particular case, where further representations are put in and no decision's been made, let's say, the individual, legally represented hopefully by this stage, will be able to seek a deferral. If a deferral is refused, then he can judicially review the refusal of the deferral.
He could seek a deferral now. So under the policy as it was when FB brought his challenge, that deferral option, as I understand it, wasn't there and it was amended. But
we're looking at the current.
Now we're looking at the current policy. There is an opportunity for the person to seek a deferral, but whether you get a deferral of the removal window is still a discretionary decision that will be received or may be received after the notice period has expired. You won't necessarily get a response to I need to extend that 72 hours from the Secretary of State within the 72 hours, and unless you do, if the decision comes in the window, which is yes, time has been extended, then that's great for you. If the decision comes in the window, no, I'm not going to extend time, then you have no remedy, because time is not extended, you still have no decision, and you have no recourse to the court, because you could be removed at the next minute. In fact, it could be, I'm not going to extend the time, here's your adverse decision, and I'm going to remove you all in the same moment. And that's just the logical consequence of the policy. It may be not how the Secretary of State intended it to operate, but that is certainly within the capacity of what is inherent in this system. So, just for as an example, say for example with FB's case, if he had said, I want to bring an asylum claim, but I need more time, and I want to bring a claim from Afghanistan, and the Secretary of State responded saying, no, I'm not going to extend the time for whatever reason, you've had the opportunity to bring your claim before, or it's not substantially different. And anyway, I've looked at my guidance notes, and they say that Afghan claims are unlikely to succeed because of the new country guidance notes. He wouldn't be able to challenge that decision, because if it's a risk of it coming out in the window period, he could then be removed without notice. But there's a reality, which is that that's not just an erroneous decision or a risk of an erroneous decision by a caseworker. There's a whole cohorts of cases that have been wrongly refused on that basis because of ongoing litigation and so on, as you can see from Mr. Hussein's most recent witness statement, for example, about the numbers of people who were taken off charter flights to Afghanistan and then successfully won their appeal. So there is a core, the discretion of the Secretary of State, how that discretion to extend the window and when she's going to notify is at the core of this case, which is that those discretions all exist. The Secretary of State relies on them, but what they can't do is offer you the access to a remedy that is needed. Now we don't, it's not suggested that one would necessarily have to have an automatic suspensive remedy in every single case. What we need is an opportunity to access the court to seek a remedy. The court might turn you down. If the court turns you down for whatever reason, because your case isn't meritorious, or your solicitor might say you've got no merits because the case is hopeless, whatever it is, but you need the opportunity to seek the advice as to the merits, and then, if necessary, lodge a judicial review, and, if necessary, go to get the injunctive relief from the court. And that's what you don't get in this policy. There's no guaranteed access to that, and that's what we say is the mischief, and the discretionary safeguards simply are insufficient because they don't allow you to access the opportunity to access the court. Not that you should a guaranteed suspension in every case. They offer you the opportunity to get the appropriate access to advice, if necessary, in proceedings, and then seeking the court's relief if that's what's required. And that's why we say that the way the policy is framed, which replaces the right of access to the court to challenge an erroneous decision by the Secretary of State with nothing, means that your representations, it means that system is inherently unfair, and therefore it inherently infringes the right of access to justice on the relevant systemic legal tests. Now I appreciate that my Lord Justice Hickinbottom in Woolcock looked at one of the criteria, looking at the full run of cases. But in the context of this analysis of systemic unfairness, and we'll come on to that, and I know Ms. Kilroy is going to take you to the cases in detail, I think. But in order to evaluate that, one has to look at what is the target of the...
I'm not sure that that's right. Sometimes these cases are brought by an individual, like Mrs. Woolcock, and on the basis of her case, she is seeking systemic relief, as FB was. Yes. In his case. I mean, medical justice is simply a systemic challenge. There's no individual. But if there is an individual, the individual can't show, usually, systemic failure simply by showing that there's been a failure in his case. So then you've got to have some other evidence, and that's where you have to look for other evidence. The main thrust, as I understand it, of Miss Kilroy's submissions is looking at things entirely the other way around. She's looking at the system. She's looking at the policy, and she says, just look at the policy. The policy does not give you access to justice. And then the evidence simply goes to show that these things can't be done within 72 hours. They just can't be done. And the individual cases, the evidence from the individual lawyers and representatives all go to that. But she doesn't start with an individual case. She starts with the policy.
I appreciate that she starts with the policy, but and of course that's inevitable in her case, but what we say is that what can be done in the status quo scenario and the following Walker is that individuals, if they're notified of removal, can do something. They can get to the court. It may be inadequate in many ways, because what the original way the case was originally put was that 72 hours wasn't long enough due to a series of issues in relation to legal aid and so on, and the greater demands on representatives. But as a minimum, 72 hours notice of removal was a way, coming back to addressing the Secretary of State's point about, well, what are the appellants offering, so to speak, is a way of at least making provision for access to the court in a meaningful way, because the meaningful way has to be somebody who's had a decision from the Secretary of State, or otherwise you'll be left with what we posit would FB arguably could have done or should have done, which is to get an injunction preventing his removal within the 72 hours, irrespective of whether he'd actually managed to bring his claim, articulate it, have a decision from the Secretary of State or whatever. So that's why we say that whether you look at it from the individual case, and it's not a single individual aberrant decision or whatever. This is an individual, like many individuals who bring protection claims, further representations for protection claims, or whether you evaluate it from the other perspective, which is look at the system. Is it inherently unfair? Because what does it risk? And because there is that fundamental point where just by being in the removal window, you can be removed without notice, even though, and therefore, which means you have to get injunctive relief to prevent your removal. But in circumstances where you don't have a decision from the Secretary of State, that's the mischief. And I can't, in my submission, understand how the Secretary of State can answer that point, because she's then inviting the court to rely on those individual discretionary decisions, acknowledging that some of them will be wrong. We provided evidence, and Ms. Kilroy has also, of numerous occasions where things have gone wrong, and the only remedy to correct where things go wrong is to have access to the court. And it won't be the reason we say that the upper tribunals, where the upper tribunal went wrong, was because their only focus was on abusive cases, I would say, and not, of course, all late claims are not abusive, as Mr. Tufik Hussein's witness statement about the Afghanistan injunctions and so on. In relation to you have change of country conditions, change of country guidance, change of personal circumstances, fitness to fly, all those sorts of scenarios, which mean that there will be proper and lawful reasons why people bring claims which they haven't brought before or articulated in the same way.
You're content with a 72 hours notice of removal?
Of actual removal.
Now, within that 72 hours, all sorts of things can happen, including, as I think all of us on the bench know from experience,
Yes.
Further submissions can be made.
Yes.
Now, once those submissions are made, the individual has two courses. One is to ask the Secretary of State to exercise some discretion to cancel the removal directions. Secondly, go to court to get an injunction.
That's right.
So why doesn't an individual with a window have exactly the same opportunities?
What the individual with the window could ask the Secretary of State to exercise discretion to extend it, but you don't guarantee. But there's no guarantee of a response within the notice period. So you'd have to invite the discretion and still go to court and get an injunction, because the timescales are so short. One just doesn't know whether one's going to be removed or not, or whether the discretion's going to be, whether the notice period's going to be extended or not, or the discretion's going to be exercised in your favour.
But that's not materially different, because under the old scheme, what would have happened is the request would have been, here's some more representations. Please cancel the removal directions, and there would then be a wait until the Secretary of State either made a decision to cancel them, or if she didn't, then to apply to court. What's the difference?
Well, what we say is, if the court, what is invited by this policy, and that kind of operation of the policy, is that every person in that situation would, because they don't have a decision and they don't know when they're going to be removed, have to prematurely come to the court to seek injunctive relief.
Well, that's not an access to justice argument. That's that you're conceding there is possibility to come to court. What you're submitting is that it would result in many possibly unnecessary
It's not a,
applications.
yes,
But I think my lord's point is one that certainly troubles me as well. The window opens on a particular date and closes on a particular date. So
usually 3 months.
Usually 3 months. So when the notice is provided, the person may be vulnerable to removal after 72 hours has elapsed. So on the hypothesis you're putting forward, there is, shall we say, an argument that the person concerned is not fit to fly or has a fresh claim. Many of these are fresh claims. They've been round the houses in the past. So those arguments are advanced, the clock ticks, and 72 hours is looming and there is no answer. Then the person concerned is vulnerable to being removed after 72 hours, even if the precise timing hasn't been articulated. And I think you're accepting that the person concerned can make an application for injunctive relief to prevent removal until, at the earliest, decisions are made relating to the issue that has been raised.
They would have to, that's the only solution for them, is to go, but we would say that it's wholly, that's even more unworkable and unattractive for the court.
But what I'm trying with my lord to do is to see which argument this goes to. So it's not an access to justice argument. Is it an irrationality argument?
My lord, yes, we would say if in the current situation where if you have to treat the fourth day as the actual removal, we would say that it is an irrational aspect of the policy to require individuals to have to seek preemptive and premature injunctive relief to prevent their removal thereafter without notice, not only of the removal but also without notice of any adverse decision, and that's had a disproportionate impact on perhaps not on access to justice, but a disproportionate impact of the operation of the policy, which makes it irrational. The Secretary of State has already accepted that the policy.
There doesn't seem to me to be conceptually any difference at all between the old scheme and the new scheme, because what used to happen is that injunctive proceedings used to be issued often quite near the time of removal, and as time drifted on towards the removal, in some cases the Secretary of State agreed to cancel the removal directions. In others, she didn't. But what's the difference? There may, you say, be some more cases now because more people are subject to removal windows than were to notice of removal. I'm not sure that's right.
I think the conceptual difference, if I haven't explained it properly, then I apologise and I'll try and put it again, is that the conceptual difference is that at the end of the 72-hour period, one may have outstanding representations that have been made, and one can't be removed because those representations are outstanding. So you wouldn't ordinarily, in those circumstances, in the old days, treat the notice of the end of the window period as being the time of removal. But as soon as that decision is served, it can be served without notice.
Served without notice of what? Without notice
of removal. So you right. So I'll just repeat that just to make sure I've got it absolutely. The court's got it absolutely clear, and that I'm making it clear to the court. The person makes a set of representations. The Secretary of State can't remove them. 3538, Section 77. The claim is pending. There's no decision in that 72-hour notice period. And the person in that scenario, if they went to the court, would just be getting an injunction to say, don't remove me until I get my decision. But then they get the decision, which is in the removal window period, and then they can be removed without notice. So the injunction would only last insofar as the ordinary injunction anyway, would only last insofar as that decision was made. And once it's made, it can be made without notice and off the person
Right, so
goes.
just to try to unpack that.
Yes.
If it's a claim for protection,
Yes.
then your submission is that the Secretary of State, under her policy, can't remove whilst that claim is being considered, even
That's
if it's a
right.
fresh one,
Yes,
under 353A. All right, so there's no need for any intervention from the courts during that period. So I think that's what you're saying.
There's no legal need for intervention from the court because the person can't be removed. But if those 353A representations are under consideration during that 72-hour notice period, one may need to seek the intervention of the court, because once the 72 hours has ended, the Secretary of State may then serve an adverse decision without any notice of the actual removal.
So to put the submission in a different way, the crux of the submission, as I understand it, is a complaint that, in your example, there will be other examples, but in your example of a fresh submission, once the paragraph 353 decision is made, this is not a fresh claim. You do not have 72 hours to go to court, well, any time.
You have no time.
You have no time before you're liable to removal. That's the submission. That's
Not liable, before you are actually put on the plane.
Before we,
Yes.
before
I mean, the reason we're using the word liable differently is because we say the 72 hours, the notice period, is notice of liability to removal. The reason one doesn't treat the 72 hours notice or one shouldn't treat the notice period as being actually removed, because what can happen in that circumstance?
No, I'm sorry. We know that the individual might not be removed the next day, but the submission is, as I understand it, as straightforward as that. That what is being denied the individuals is an opportunity, is access to justice in respect of, in your example, the paragraph 353 decision. There'll be other examples and other discretionary decisions, but that's the
That
crux
is,
of
I mean, in the international protection context, that is, which is.
Well, in any context,
Yes.
a common law will do, because you're denied access to
Yes,
justice.
that is the.
You don't have to go elsewhere.
That's what we say is inherent within the policy.
Yeah.
So, and the operation of the policy. But the reason I sort of paused over the word liable is because what a person who requires leave and doesn't have it, any person who's been here for 3 weeks, 3 years, or 3 months, whatever, they don't have leave, they're liable to remove, they can be removed. But there is a process that needs to be gone through, and if the Secretary of State's rationale for this policy is her service of the Section 120 notice, and her policy objective, which is to encourage early submissions, is the way she puts it, just to encourage them. And it's of course laudable to encourage early submissions, but there's no recognition in the policy that late good claims will be brought, that may need access to justice because the caseworkers may get the decisions wrong for a number of reasons. That is a material flaw in the policy. And unless there was a recognition of that, and it can only really be rationally addressed by giving notice of removal, we say, because any other mechanism leads to preemptive strikes and going to the court, taking up the time of the court, and perhaps unnecessarily, because the person may not have a good claim, in which case they will be removed, but they won't. The target decision is the decision on the 353 claim, and the operative target for the judicial review is their removal, after which they won't be challenging their removal because they will have been removed.
Well, I mean, I think we have the submission now. Just to see if I've made a note for myself, so I just want to be clear that I have got it right.
Yes.
The policy allows the service of a decision rejecting representations, whatever they may be, and immediate removal without an opportunity to challenge.
That's right.
That's it. So the 72 hours is of interest, but that's the real vice, as you put it.
The real vice is not having notice of when one is being removed, and
Yes.
that's and therefore we say it's incompatible. The three grounds that we put in our amended grounds, which is that notice of removal is required so that you, for anna frieva purposes, to make it consistent with public law duty to give notice, and there's a duty to give notice in a reasonable period of time. And the third principle is it's a denial of access to justice, and therefore ultra vires section 10 of the 99 Act as amended. I wonder if I might just take the court to section 10. Anna frieva and some of the authorities. So if I could just have a take a core bundle.
Is this volume 1 of the authorities?
Volume 1.
Yep.
Sorry, it's tab 3.
Yes. So this is the most recent
So the most
iteration.
recent. So actually, sorry, bear with me. If we just go back to tab 2, which is the old version. So the earlier version is a person who is not a British citizen, this is section 10.1, may be removed from the UK in accordance with directions given by an immigration officer if, and it says A, B, C and D, which is you're an overstay, don't use conditions, deception and so on. And that directions would be maybe given for removal. Then we go to section tab 3. Section 10.1. A person may be removed from the UK under the authority of the Secretary of State or an immigration officer if they require leave to enter but do not have it. And then over the page 10.7. For the purpose of removing such a person under subsection 1 or 2, the Secretary of State or the immigration officer may give such directions for removal as the person that may be given under schedule paragraph 8 to 10 of schedule 2 of the 71 Act. So that's the provision about removal that's been there since the beginning, as far as I can see. So the court, we say that the Secretary of State's case was before the tribunal, and I think it still is before this court, but there's something in section 10 that allows her, the amendment to section 10, that allows her to change her position from previously being required to give notice of removal. And the tribunal expressly rejected that at paragraph 154 to 155. So perhaps we just go, I'm going to come back to that authorities bundle to look at anna frieva, but just on the statutory interpretation point, the judgment of the EPA tribunal is that core bundle, if it's tab 10, page 1 through 7, but it's paragraph 154, 155. The same submission was made to the other tribunal, but you can see there, 153. In oral submission, the applicants and PLP said if one compares the present versions that existed prior to the replacement, one sees that prior to the replacement by the Immigration Act 2014, one sees for our purposes that nothing very much has changed. In both the old and the new versions, the power of removal is given by the legislature. Mr. Justice Lane, that's not quite right. Then he sets out the old power and the new power. The old power says the person may be removed in accordance with directions. By contrast, the new power, section 10, is 4 lines down, provides an entirely freestanding power of removal under the authority of the Secretary of State or the immigration officer. It's not until which is 10.7 that its new incarnation that one sees that the Secretary of State or the immigration officer has the power to make those removal directions. But what they say, 153, is that said, we're doubtful whether anything of substance turns on the differences, and accordingly we agree with the applicants in the PLP that the respondent cannot derive any material support for his removal window policy.
So where are you reading from?
155, my lord. Cannot derive any material support for his removal window policy from the change in the wording of section 10. And indeed, Mr. Kovacs didn't seek to argue to the contrary. I'm confident that I've seen Mr. Kovacs's and the evidence that's relied on by the Secretary of State directly suggesting that section 10 changes the operative position, but Mr. Kovacs can deal with that in his response. So having identified that this doesn't come from a statutory authority to no longer have to give notice, then the only...
Sorry, but why can't a removal direction, I know that all of these now have terms of art, but why can't a removal direction under now section 10.7 simply say we're going to remove you, and we're going to remove you from between next Wednesday and some date in the future? What's wrong with that?
Well, then you come back to, if that's correct, then we say it breaches the Anna Free-Ava
Oh,
principle.
that's a different point.
But
It's a different point. I understand that. But why? But on this point, which is about what the statute says, what's wrong with that?
Well, we say that given that the framework of the Act, of the Immigration Act, the rights of appeal all depend on refusal of claims.
Well, there's no appeal against removal directions.
They're all in relation to the vision and the Article 3 obligations all relate to removal. So in my submission, if you read that paragraph along with the way in which the obligations under the appeal obligations arise, which is that one's removal in consequence of a refusal would be a breach of the UK's obligations under the ECHR or the Refugee Convention, that's why the notice, where removal had always previously been notified, absent an express provision that it's not going to be notified on a particular date, that's how, to read the scheme, the statutory scheme consistently across the 2002 Act, which provides for the right of appeal, against where the grounds of appeal are about removal from the UK. It's that scheme which we say has to be read consistently with the requirement to give notice. I also just want to take the court to paragraph 8 of Schedule 2 to the Immigration Act 1971, which is the original provision about giving removal directions, which still exists and was there from the beginning. So that's in tab 1. It's behind tab 1. It's internally paginated. And it is... It is at page 23, I hope, of my rules.
I'm sorry, which page?
Page 23. I mean, perhaps it may not entirely answer my Lord's question directly, but this, as we say, is relevant to the way in which the interpretation should be seen. Paragraph 8.1. The person who refused leave to enter an immigration officer may, 8.1a, give directions to the captain to remove him, give the owners B directions to remove him, and you can see that there's no directions under 8.2. No directions shall be given under this paragraph in respect to anyone after the expiration of 2 months beginning with the date on which he was refused leave to enter.
But I'm sorry, I think I'm a bit lost in these submissions. These give a power to an immigration officer to notify people like the captain of an aircraft which is going to remove somebody, that he's going to have to remove him. That doesn't seem to me to be unreasonable. But there's nothing here express that which says that notice has to be given to the individual, you say that obligation arises out of anna progeria. Well, I understand that.
Yes.
But is there any construction? You're putting this forward as a construction point, and I don't see any construction point.
My Lord, the reason that the Secretary of State, as I understand the Secretary of State's case, put her case as to the requirement or the lack of a requirement to give notice of actual removal directions squarely on the amendments to Section 10, where previously she accepted that there was a statutory requirement to give directions. That's what she says she was doing in her enactment in the 2014 Act by the changes to Section 10. The Tribunal reject that argument. And that, we say, as I understand it, was the whole...
That's what you've just shown us.
Yes.
But it also recorded that it wasn't the submission of Mr. Kovacs.
Yes, well, I can find the reference in
But
Mr.
anyway.
Kovacs' previous
we're-
but we don't need to. I don't need to worry
No,
about
no, no.
that.
I think again, my lord is seeking to understand whether your submission includes the proposition that the statutory scheme requires the service of removal directions upon the person being removed, or whether it's as a result of the speech of Lord Stayne.
My lord, our primary submission is that there's nothing in the amendment to Section 10 that allows the Secretary of State not to give notice. The previous version of the Act and all previous practice, and maybe it may be the Secretary of State was in the past giving notice of something she didn't need to give notice of, but I don't contend for that. What we say is that previously, prior to the amendments to Section 10, the Secretary of State did give notice of removal directions, actual directions, and there's nothing consistent with Section 10 as it was under Tab 2, consistent with the operation since 1973, 1173, under the schedule, paragraph 8 of Schedule 2. So she's always been giving those directions and notifying them under ordinary public law principles. That's how that statute should be interpreted. And what she sought to do, we understand, and if Mr. Kovacs has departed from that, or I've got it wrong, then I do apologise, that changing her was to change to rely on the changes to the Act to say that is not required. And I accept that it's expressed in terms of a power, that if the alternative submission is that the power has to be exercised lawfully in light of the public law duty to give notice that are in the anna free sense, and that is the alternative way to look at that, how that power should be exercised. But it's notable that in the statutory scheme, the reference to removal directions remains. So it remains an offence, for example, to evade removal directions, for example, under Section 24 of the Act. It remains an offence you can't be granted bail if directions are enforced, if removal directions are in place within a certain period of time. So in those, given that there is reference throughout the scheme to removal directions having an operative effect on your status and your obligations to the state, it does seem, it would be very surprising if the statutory scheme isn't read in the way that requires notice of removal. My lord, I'm just going to take Court Anna Free over. It's tab 18. Sorry, tab 17. These are also, just coming back to where we were in our skeleton argument at paragraph 36. So what we say is the anna free principle is the means individuals have the right to know of a decision before their rights can be adversely affected. So we see what the facts are in the summary headnote at page 249, that the applicant was seeking asylum, her claim was refused, and there was a note, an internal case note that said the case is determined. That was communicated to the benefits agency. Benefits were cut off, but the person wasn't notified of the refusal of their asylum claim, and they only found out ultimately when their benefits were withdrawn. So, just picking up Lord Stayne at 21, the question he identifies is whether, and this is in the context of those particular income support regulations, is whether Parliament intended to authorise the withdrawing of income support by an internal note on a departmental file with legal effect from a date before the notification of the issue. And he expressly notes at paragraph 21 that the decision of the House may have a general bearing on the development of our public law. So, at paragraph 26, and this is where the core point arises, the submission or the conclusion of the court below was that the person wasn't entitled to notification at that time, at the time of the decision. And bear in mind, obviously, what was being refused there was less fundamental, which is, although very clearly of great significance and importance, was the refusal of asylum and the refusal of benefits, not the refusal of representations which lead to removal from the UK. But obviously of great significance and higher standards of fairness are called for us by as Lord Stayne indicated there. But at paragraph 26 it says, the arguments of the Home Secretary ignore fundamental principles of our law. Notice of a decision is required before it can have the character of a determination with legal effect, because the individual concerned must be in a position to challenge the decision in the courts if he or she wishes to do so. It's not a technical rule, it's simply an application of the right of access to justice, and it accords with fundamental constitutional principle in Raymond and Honey, Sims, and the court obviously is very familiar with those cases. Obviously, the court has to interpret it compatibly with Section 6 of the Human Rights Act. What Lord Stayne emphasises at paragraph 28 is he says, and perhaps this is more, I would have hesitated to use the language that Lord Stayne did, but he has used the language. It is reinforced by the constitutional principles required by the rule of law to be observed. The principle 2 requires the constitutional state must accord to individuals the right to know of a decision before their rights can be adversely affected. The antithesis of such a statement is prescribed by Kafka, and he goes on to talk about that scenario. An attic removal without notice, which interferes with the legal obligations owed to the state and the actual impact on the person, without notice, in my submission, is entirely consistent with what Lord Stayne found objectionable there about not being notified about a refusal of asylum that meant you didn't have access to benefits, let alone what we're actually concerned with here, which is obviously something more significant. So then he explains at paragraph 30 why until the decision in Salem it had never been suggested that an uncommunicated administrative decision can bind an individual. It's an astonishingly unjust proposition. In our system of law, surprise is regarded as the enemy of justice. Fairness is the guiding principle of our public law. And then he's at the bottom of paragraph 30, elementary fairness supports the principle that a decision takes effect only upon communication. And if this analysis is correct, it is plain that Parliament has not expressly or by necessary implication legislated to the contrary effect. The decision in question involves a fundamental right, and in effect it involves a binding determination as to status. And the last two lines of that paragraph given this context, Parliament has not, in specific and unmistakable terms, legislated to displace the applicable constitutional principle. And so,
In the case that we have with the removal window policy,
yes,
if the individual has access to justice properly before the window starts, he becomes liable for removal. He still has access to justice in respect of anything he wants to do, in respect of an underlying decision or a discretionary decision by the Secretary of State. So, how is there any denial of access to justice as opposed to where the removal direction is notified?
my lord, the primary point we say is that the removal window is not notification. It's not compatible with access to justice because it's not equivalent to being notified of being removed. So one may have had. I think my lord premised that question.
Sorry, can I just say that it's not the equivalent of what?
It's not the equivalent of notice of actual removal. Because what one knows, when one is given removal directions, one knows that is the date upon which one is going to be required to leave, and be removed from the UK to, in our case, Afghanistan.
Subject to the usual.
Yes, so that's...
So why is that different to being told that you're going to be removed within a 3-month period? It's not a set date, it's just a period. But other than the temporal difference, I'm speaking for myself, I don't see the difference.
In the applying the, and this was applying Anna-Free Ava, we say you've got a requirement of a duty. There's a duty to notify the actual decision, not that you will be refused benefits in some period of time, but that you're actually going to be. So it will be refused asylum in some period of time, but they're actually going to be refused because of the impact on your status, which is, in that case, your access to benefits. In this case, the obligations under the convention.
What about if the decision in Anna-Free Ava was, the decision, unnotified, was that we're going to remove benefits in 2 weeks' time?
Well, what Lord Staines...
The important words, it seems to me, are in paragraph 26, and that is, because the individual concerned must be in a position to challenge the decision in the court. This Anna-Free Ava is an access to justice case.
My Lord,
and that's what, in Anna-Free Ava, they were robbed of.
I mean, can I just take my Lord to paragraph 32 and also paragraph 35, and then I'll come on to just respond to how the tribunal analyse it and what we say in response. What Lord Staines says is that Counsel for the Home Office admits that before a determination can be notified, there must be a determination that that's legalism, protectionism run right. One can readily accept that in this case there must have been a decision as reflected in the file note. That doesn't mean the statutory requirement of determination has been fulfilled. On the contrary, the decision is provisional until notified. So what we say here is that when you are given a notice of removal window, what you're effectively being given is a notice of liability to removal appreciate in a more defined time frame, because you might have been here for a long number of years, or you might, as Mr. FB, have been here only for a couple of days. So, but it's still a liability. What's being invited then is, can you make any further representations to us? That's what the Section 120 notice does. That's what the Secretary of State serves along with the notice of removal window. So she's asking for something, but what she's not doing with her policy is then, and this is why we say it's different from removal direction. She's not saying, I'm going to decide that, I'm going to respond to your 120 notice before I remove you. She's saying, well, I may do and I may not. But if I do it after the 72 hours, you won't get any notice of the removal.
But that's coming back to your own
Yes.
submission.
Yeah, but And sorry, and so the final point in relation to that is that, sorry, if you, I'm sorry, I just lost that. So what we say is, having invited those submissions, your liability to removal is effectively provisional. It's not notice of removal directions, it's provisional because you don't know whether you're going to be removed until the Secretary of State has taken a decision to respond to your representations, and that's why it's provisional. And it's provisional in the context of the Secretary of State knowing that she has obligations to you, international obligations and domestic in relation to your status. And we know again, because of 353A, that having invited those representations, she can't remove you. So that's why we say that that the Anna Frieva principle still is applicable. I'll just take you to paragraph 35 and then just come back to what the Tribunal say about Anna Frieva and what we say in response. So the paragraph 35 is that Lord Justice Steyn says that Lord Bingham has observed the Secretary of State was under a public law duty to give notice within a reasonable period of time. But this breach of this duty cannot nullify or invalidate his decision. I question this completely. It's important to bear in mind the breach involved a deliberate policy decision by the Secretary of State not to comply with the public law duty. This amounts to an abuse of power and ought to preclude the Secretary of State from relying on his unlawful conduct until notification has taken place. So rather than say, well, you need a reasonable period of notice in order to access justice and so on, he's actually saying that because of the policy of withholding the decision, that's what is objectionable about the decision under challenge in Anna Frieva. So if I may just take the court to what the Tribunal's response to this was.
Yes. So this is back to the decision that starts at page 137.
Paragraph which? Oh, sorry.
So sorry.
No, sorry.
It's at paragraph 152. So Mr. Kovacs, 152, Mr. Kovacs' response to Anna Frieva was that the circumstances of the present cases and those of Anna Frieva are not remotely analogous. We agree. In order to be analogous, the respondent's policy in the present case would have to involve putting the applicants onto an aircraft in order to remove them from the UK without any prior notification that the respondent intended to do so. That's manifestly not the position. We say our response to that is no. An analogous position to Anna Frieva would be that the respondent indicates that she's considering refusing your asylum claim or considering whether the final determination of it, which will have an impact on your status, invites representations, but then doesn't communicate the decision to you, but does communicate the decision to the benefits agent. So that's the way to apply the analogy in Anna Frieva, such that it still comes back to a requirement to give notice because, as Lord Steyn indicates, the person must have the opportunity to challenge the adverse decision.
Well, the notice has the effect of saying, I, the Secretary of State, have concluded that you have no legal basis to remain in the United Kingdom, and therefore you will be removed within a window.
But it equally, it simultaneously, apologise for interrupting,
yes,
it simultaneously invites further representations.
Yes.
And so once it does, which isn't in itself objectionable to invite the representations, that's what it's a good policy. But what is objectionable is then not to agree within the structure of the policy how the decision has to be taken before removal. It has to be, because we know 353A and 7.
Well, if it's one of those cases,
yes, if it's let's just focus on those for the moment. We know that they have to make those decisions, and that the policy doesn't make any provision for when those decisions are going to be made vis-a-vis the actual removal, and you're not notified of them. And so we come back to the point we were at before,
yes.
which is that you either seek preemptive access to the court, which is irrational and unworkable, or it has a disproportionate impact on your right to access justice, because you may not, quite from the examples that we've seen, which are more than de minimis, which will come just, I think the final sort of strand of this is to look at what the threshold test should be.
But this does come back to the same submission, in fact.
My lord, I think yes,
And
there is
so-
an element of circularity I appreciate within my submissions.
And
But
it may well be that there are 2 points in your submissions when they're boiled down. The first is the one we identified a little while ago, that the policy allows service of a decision rejecting representations of whatever sort and immediate removal without an opportunity to challenge. You put that in 2 ways. First, it's ultra vires section 10. Secondly, that it is incompatible with the principle identified by Lord Stane and agreed by all bar Lord agreed. I think by all. Lord Bingham's dissent was on statutory construction in Anna Friheva. And then the second point is that the risk of that happening is not de minimis, and thus applying the test that you articulated at the outset of your submissions.
the inherently liable to
Yes, is inherently liable to expose to more than minimal risk of unfairness. That those taken together means the policy is unlawful.
My lord, yes, if I can just, I wanted to just further emphasise the Anna Friheva point with one reference to Lord Dyson in Lumber. So that's at volume 3, tab 35.
Tab 35.
Sorry, volume 3, tab 53, paragraph 4. I appreciate that the context in this was in relation to detention and the policy, and the court, of course, very familiar with this very lengthy authority, but just for the proposition that Lord Dyson emphasises there, which is 34, the rule of law calls for a transparent statement of the executive and circumstances in which the broad statutory criteria will be exercised. Just as surveillance and arrest powers need to be transparently identified through codes of practice, and immigration powers need to be transparently identified through immigration rules, so too the immigration detention powers need to be transparently identified through formulated policy statements. So, in some ways, analogous to where we are here.
So it's paragraph 35.
34, then I'm going to 35,
Yes.
so I'm so sorry. And then, so where we are here, obviously, is that we're dealing with a secretary power of the section 10 that is operated through the removal directions, and then the policy is what is the target of this challenge, is that if there is a power to remove without notice per se under the statutory scheme, the individual has a basic public law right to have his or her case considered under whatever policy the executive seeks fit to adopt, provided that the policy is a lawful exercise of the discretion conferred by the statute. So the discretion conferred by the statute here is the discretion to remove, the discretion to give directions. So the policy, if that's in that second scenario, and then the correlative right is to know what the current existing policy is, so that the individual can make relevant representations to it. And in order to emphasise that point, Lord Dyson goes back to the paragraph from Lord Stane in Anna Friheva about why notice of decision is required. so that one can be in a position to challenge the decision in the courts, and it is an application of the right of access to justice. So,
And the problem here was that there was a policy which was being applied, which was not in public.
that wasn't published, yes. So it is. I accept that the context is a different context, but the emphasis as to what public law requires and why they're not in the context of the more radical decision to remove a person from the UK, but rather they're in relation to the detention of certain categories of foreign national offenders. And so that's why we say that is an important reinforcement of the application. And some may say, as noted here by Lord Kerr, don't have to turn to the 243, that removal from the UK involves detention of the person. It is a physical act affecting their status, of which we say, as we said in our first argument, that there needs to be notice because of the impact on the individual and their status in relation to the state. The state taking that fundamental interference with their personal rights. So just then moving on to what is the test. And my lord, about it is for inherent unfairness, and perhaps we can take this relatively briefly. I think Miss Kilroy may well to take you to the authorities in some depth after lunch. But the test for inherent unfairness is whether the scheme is reasonably capable of operating lawfully. Now we say in our skeleton argument, with reference to, just bear with me, this section of the skeleton is at paragraph 42. So the first reference there is to unison in relation to the right of access to justice and how the statutory power should be interpreted, particularly where if the statute contains no authorising words preventing the right of access to justice, and the enactment will be ultra vires if there's a real risk the persons will be effectively prevented from having access to justice. So such an enactment to unimpeded access to the court can only be removed by express enactment, and impediments to the right of access to justice can constitute a serious hindrance, even if they don't make access completely impossible. So there, of course, the court was dealing with the regulations, the fees regulations in relation to the employment tribunal, so not the primary legislation. But obviously this is a question, we say, question for the court, but with reference to Citizens UK, and that I think that authority was handed up now at the end of the. You don't need to turn it up, but it's now in the additional authorities end of the authorities bundle at tab 72A for questions that need to be removed.
So which authority is that?
Citizens UK.
Yes.
It was not in the bundle. And it should be at 72A. Actually, it would be useful to know if it is there. So it was made it.
What, for you or for us?
Well, I think so we can breathe a sigh of relief.
Yes, well,
It is not there.
it has found its way into my bundle, and I can take no credit for that
Well,
personally, I can assure you.
Very grateful to you, however that landed. But the proposition there, as the court will be, this court very familiar with this, is the question of fairness is a question for the court. And in the context of asylum and human rights, highest standards of fairness are called for, both in from Anafreba and also from detention action, which is Lord Dyson, just give you the reference, at tab 21 from the core bundle. Paragraph number. Which is paragraph 27. I don't know if the court wants, perhaps we could just go to that authority.
So
So it's the core bundle. This is the detention action.
the react appropriately to ensure fairness.
That's correct. Yes.
Yeah.
So
27.
So it's paragraph 27 of tab 21.
Ah,
and the
sorry, I was in the
core
wrong
bundle.
tab.
I know
My
that it doesn't go
fault.
around.
21, para 27.
Yes.
Yeah.
So there, the court accepted the general principle summary from Mr. Eady, from the Secretary of State. And again, this is, I think my Lord Justice Hickinbottom looked at this in Woolcock. But so the core question is whether the threshold of showing unfairness is a high one, that's Little Roman 4. Little Roman 5, the core question is whether the system has the capacity to react appropriately to ensure fairness, in particular whether challenge is directed to the tightness of the time limits, and whether there's sufficient flexibility in the system to avoid unfairness, and whether the irreducible minimum of fairness is respected by the system and therefore lawful is ultimately a question of a matter for the courts. And then, having said, when he has gone to say that it shouldn't be taken to dilute the importance of the principles that only the higher standards of fairness will suffice in the context of asylum cases. So, when my Lord was looking at the important context in all the cases that we've looked at on systemic unfairness, say for example in Woolcock, are we say necessarily context specific, which is in the scheme of what was presented there in relation to the practice of magistrates for non-payment of council tax. Was it individual aberrant decisions, or was there something systemically unfair? My Lord evaluated the evidence before him and looked at the impact in that context and concluded that there wasn't. But by contrast, as we point out in our skeleton argument, we set out that threshold in paragraph 44 of our skeleton, in the quote from Woolcock at length, which is at paragraph 68 of Woolcock. My Lord set out in full in the skeleton the reference
Which paragraph of the skeleton?
sorry, it's paragraph 44 of our skeleton argument.
Yes. Ah, yes.
So it refers to my Lord Justice Hickinbottom's judgment in Woolcock, which itself we will find at volume 3 of the authorities at tab 67, and the relevant passage, particularly summarising the key propositions, and usually we set it out in full there at paragraph 68, but still 44 of the skeleton, it should be page 18 of the skeleton argument. So, as we identify paragraph 45, it's concerned with the lawfulness of the policy of in relation to enforcement of liability for unpaid council tax by way of imprisonment. And again, of course involving important rights of the state not to deprive persons of their liberty, but in the context of whether it was an appropriate, the relevant sentencing regime was lawfully consistently applied. So by contrast, we say, and perhaps more appositely here, paragraph 46 of our skeleton takes up the case of BF Eritrea. And that there, this court held that the Secretary of State's policy on age assessments, which was back to discretionary decisions taken under policy in relation to whether or not to detain persons that the Secretary of State thought were children. The court concluded that this was an unlawful policy because it failed to ensure that the decision maker took into account there the wide margin of error. And Lord Justice Underhill didn't take the approach of looking at statistics necessarily and saying, well, this many cases went through the system and this many were wrong. He actually approached it from the perspective of looking at whether the policy was deficient in doing what it was rationally supposed to do, which was determine whether or not a person fell within the appropriate criteria for not to be detained, i.e. when they were a child. And so, effectively, what he concluded was, and this comes back to I think the Secretary, the suggestion that, so in unison you have 60 or 70% drop off in employment tribunal claims. In other cases you have significant numbers. In our case, we of course do have evidence through medical justice of a number of instances where there have been wrongful decisions and wrongful removals, and Mr. Justice Friedman characterised those as effectively examples which didn't inform the principle. But if you apply the approach from Lord Justice Underhill in BF Eritrea, in my submission what the court gets is that as long as it's not a de minimis risk, and bearing in mind that we're dealing with a policy, not, for example, as my Lord Justice Hickinbottom was dealing with in the JCWI case, the statutory scheme, which in relation to the right to rent, and I can just take, I haven't got that case in the bundle, but I've got the analysis of it.
Just before you move on, could you remind me of the reference in the bundle for BF Eritrea?
Yes. I think perhaps I can write on
Tab 70.
Take the
70, thank you.
Tab 70, it's bundle 3.
It seems to me that this case, on the basis of your submissions, this case is different from many of these other cases because you say that the policy is that once, in your example, the paragraph 353 decision is made, then removal can be effected immediately without any opportunity to challenge judicially the refusal of the 353 decision. So that's the policy working properly. That's the design of the policy. There's nothing within the policy that stops that happening. There's nothing to say you get 72 hours after a decision or anything like that. That's the policy working properly.
That's as the Secretary of State intends the policy to work, and we say it's that which is causes them.
Exactly. Whereas in some of these other cases, what was happening was there were aberrant decisions, and it was whether there were so many of these decisions that it became a systemic error. It seems to me to be.
Perhaps it may be that not a great deal is to be learned from all these systemic unfairness cases because they all turn on their particular context. But one of the reasons of taking the court to these is partly to show that the approach isn't necessarily a statistical one. The evaluation of systemic is about the context. Is it inherently liable, back to the point I think I made at the very beginning, liable to lead to a real risk of there being a denial of access to justice and a risk of refoulement in breach of the UK's international obligations.
But you say, looking at the formulation of Lord Justice Underhill in BF, you say this policy is not capable of being operated in a manner which is compatible with the right of access to justice. That's your submission.
Yes,
Because
we're not given notice.
because under the policy, as soon as the decision comes in on the paragraph 353 submission, then you can be removed.
Yes,
I mean, it may be that in an individual case you're not removed for one reason or another, but that's not as a result of the system. That's a result of aperture.
This is it's so structural and so far removed from what we have been used to seeing. It is a huge departure from this. As I say, it's why it's generated such a lot of paper. The court may be thinking. I appreciate the court was perhaps concerned with why we had put in so much evidence, and Miss Kilroy wants to take you to that. But that's because it is represents a fundamental shift from what had been in practice since 2008, effectively, since the agreement with the courts that there would be notification of removal and that what one had actual removal, and one had 72 hours if one wanted to bring a challenge, a minimum before the court. And what the court then looked at in Medical Justice 2010 was whether there could be any exceptions to that, and concluded that there couldn't be. So what this policy...
I'm sorry to interrupt,
yeah.
but your submission, it seems to me, is a very, very simple one, and that is that this policy is systemically bad because, for exactly the same reason, that zero notice,
Yes.
the zero notice policy was bad, or the exceptions policy was bad in Medical Justice 2010.
Yes.
That's why it's systemically bad. It's exactly the same situation, you say.
Yes. Once there is a provision for zero notice of actual removal, it is. Yes,
I wouldn't, it's just that you do not have any opportunity to judicially challenge a material decision.
Or it may not even be judicially challenged. You don't have any opportunity to consult with your lawyers. They've got this decision. What should I do with it? Is it good or bad? How would you advise me? And you may be needing to seek advice that says, actually, you've got the end of the road. We can't do anything more for you. You should. That's it. Which also assists the court not having lots of people bringing preemptive strikes because they haven't got those decisions. And it is also as stark as that, and it is why perhaps looking at the other context of those systemic unfairness cases may not exist. There's only one case I wanted to perhaps take the court to, and it's just we say that particularly because this is not, as we say, expressly authorised by statute. There's nothing we can see that authorises zero notice, contrary to all of the principles and the application of those principles in this field about removal, this medical justice, and the context in which where there's an inherent framing of the policy which is unfair was most recently considered in the case of W. That's actually in the volume. If I could just take the court to that. Tab 28.
Sorry, it's which tab?
Tab 28 of the core volume.
What do you say that this judgment shows?
This judgment shows that how in the framing of a policy there can be an inherent risk of systemic unfairness. So this policy was in relation to the no recourse to public funds, and whether there were any appropriate exceptions to that for persons in certain categories. And so what the court did at 56 and was to analyse or to look at the JCWI2 case that my Lord Justice Hickinbottom was involved with, about looking at the question of is it capable of being operated in a way that's proportionate in nearly all cases, albeit that then there's the question about whether that's compatible with the Northern Ireland Human Rights Commission case. But Lord Justice Underhill has given us an answer for that in BF Eritrea by saying it's effectively a legally significant number of cases, it will then have to operate incompatibly, and there's no real difference between the tests. But anyway, what the court concluded was that, so they were examining the case of Beebe, which is the Supreme Court case, I think is in the bundle as well, but we don't necessarily need to go there, which concerned the rule that in relation to requirement to speak English before one could come to the UK, and in not quashing as a dependent spouse in those cases, and in not quashing the rule in Beebe, the court held that they didn't quash the rule as being incompatible because it could be compatibly operated if there were appropriate guidance. But here, in this specific case, in the W case, applying the test of the kind applied in Beebe, which is where there's a significant number of cases in which the application of the guidance will lead to breach of convention rights, the court concluded that there would be a significant number of cases, i.e. it was inherent in the structure of the policy that there would be a breach of convention rights. And that's what we say in this case, which is that even with, when one's looking at, we've got statutory, has Parliament authorised this provision? Are there pieces of delegated legislation as in Unison or in Beebe? And then we come to, is the policy framed in a way which is systemically unfair, or is it capable of being operated compatibly? And we say, applying, to properly understand the application of this policy, it is systemically unfair and gives rise to real risk of breach of ECHR and refugee convention obligations because of the zero notice provision. That conflicts with, that's the context in which, if one were analysing this from an Article 13 effective remedy standpoint, or a procedures directive effective remedy, that's Article 39 of the procedures directive, and Mr. Kovat's position is that it doesn't make any difference what test you apply because you get as much protection under the common law as you do, and that may well be correct, but if one were looking at it from the context of Article 13 and the case law, the question of whether the remedy is effective in an Article 3 case or a protection case, let alone an Article 8 case, will depend on a totality of the remedies that are available to the individual. So that includes the question of notice, access to the lawyer's access to the court, and how the Secretary of State could react and how one can challenge an adverse decision. I accept it doesn't in every case require an automatic suspensive remedy for a further submissions type case like this. For a first claim, I will accept, as in Chiari and bid loss and so on, various other cases concerned with first claims, there was the question of a suspensive remedy was what the court was, an automatic suspensive remedy was what the court was concerned with. And this Kilroy will have some examples of first claims. But even for where there are further submissions type cases, people who so in FB's case, his claim, albeit based around the same scenario of what happened to him in Afghanistan in 2007, he had been back to Afghanistan and had some further adverse experiences, which he said would rendered him risk of persecution between being removed and his return. And so he brought a fresh protection claim, or made fresh submissions for protection. And it's those that we say that is in that context where people are raising new, late but not abusive cases, that the court has to evaluate the effectiveness of the remedy under Article 13 and look at what is available to the individual. And the court, just to take you to one Strasbourg case, because I think that most of the other authorities don't necessarily assist for this context. Having looked at them, I particularly take the court to tab 30, which is Conker versus Belgium. And this, if I just take you to the facts of this case, so the facts are.
So what's the principle it establishes?
The principle is, in this case, 687, the principle there was that the persons were removed without notice. So they'd had an asylum claim, it had been rejected, and they put in further submissions that they were served with orders and taken to be removed without notice. And so, albeit it wasn't the first time they'd made a claim, they had particularised further issues that they wanted to seek in respect of which they sought international protection. And paragraph 75 of the judgment identifies that the remedy, this is about, paragraph 75, it's sidelined and it's about halfway down. The scope of the contracting state's obligations under Article 13 varies depending on the nature of the applicant's complaint. However, the remedy required must be effective in practice as well as in law. The effectiveness of the remedy within Article 13 doesn't depend on the certainty of a favourable outcome for the applicant, nor does the authority in that provision necessarily have to be judicial authority, because it's not. It's powers and guarantees which it affords are relevant in determining whether the remedy is effective. And also, if a single remedy doesn't by itself entirely satisfy the requirements under Article 13, then the aggregate of the remedies provided under domestic law may do so. So that's what we say, is that Secretary of State is relying on the safeguards, the discretions within the policy. And if under ordinary principles, there has to be a way in which those could be examined by the individual before they are removed. That is the inherent problem, the illegality.
That's going back to the access to justice point.
So, my lord, what I said, I think is probably correct, which is that it may well be.
And speaking entirely for myself, it seems to be that in terms of the test, if all of your other submissions are right, so that in your paragraph 353 example of a decision being made and served with and removal taking place immediately without proper opportunity to challenge the 353 decision, I'm not sure that numbers come into it.
Well, because it is such a structural point, that may be right. I'm conscious that I've just intended to, and didn't take you to the policy, and I think I should.
I was wondering whether we might need it at some point.
That was supposed to come to point 3, but it's come rather late in the day. But anyway,
yes.
I just want to confirm what version of the policy we're using and where. So I'm hoping
You tell us.
Right. I'm hoping that we can use version 17 of the policy, because that was the version used in medical justice, and which Mr. Justice Freeman's judgment is addressed. And also, so it's in FB's supplementary bundle, tab.
Which FB supplementary bundle 1 or 2?
1.
Yes.
That's A298.
218.
298, my lord. So, what we say, first of all,
Well, now, just before we go on, is everybody content that we look at the policy via this bundle, because the last thing I would want is for us to be taken through 3 or 4 different bundles with 3 or 4 different iterations of the policy. Mr. Kovats.
Can I be excused for jumping up? I've done all my cross-references to the version in Medical Justice's bundle.
So
Tab
have I, if
17.
it helps.
All right.
But
Well,
can I also just flag up here that the current version, which is version 20, can be found at the back of FB Supplementary Bundle 2. But the changes between what I'll call the Medical Justice version, version 18, and the current version, version 20, are not, as I understand it, material to the outcome of this appeal. I just wanted you to be aware that version 20 is the current version, and if you want to look at it, you can. It explains, I think, on page 5 what the amendments are, and they're not material to the report.
All right.
right.
Well, now, Ms. Nike, you wanted to look at version 17. Are you happy
I still want to look at version 17. I'm now looking. I'm just going to have both bundles open so I can look at my notes. I've not marked up the one in our bundle, but it's right to say that it also appears in the Medical Justice bundle.
Well, I think theirs is version 18. Am I right?
No, version 17.
Oh, it is 17.
This is
Forgive
17.
me. All right.
The only difference, so it's 5th of November 2018. 388 in Medical Justice Core. The difference there is that it's got internal pagination, as well as the bundle pagination. I think with that I can probably manage to look at
Yes.
where I am.
So version 17 is tab 17 of the core in medical
Medical
justice. That, like my Lord Justice Hickinbottom, that is the one that I have
Yes.
marked up. It just so happens that I looked at the
Yeah.
medical justice one first, and because my supplementary bundle in yours has just broken, that would be another reason from my point of
That's
view.
a very-
it would be very helpful if
Yes.
we looked
I'm
at
going
it
to,
here.
as everybody has indicated, this is the version of the policy that they use, except for me. I'm
Sorry.
going to use this version. But I'm going to.
As a preliminary question,
Yeah.
because we're using this version in this bundle, and this may be me, on page 405,
Yes.
under deferral of removal, there is I think a hyperlink to consideration of deferral.
Yes.
I couldn't find that in this version. I think I found the relevant bits in other documents, but I simply could not find it in this version. If somebody would give me some help.
Perhaps. Well, I'll look. Perhaps I will identify that just over lunch if I can.
Because later on, that may be an important
Yes.
passage.
So.
Okay, now you're going to give us page references in your bundle.
No, I'm happy
No?
to.
Are you
I
happy
should
to-
be able to manage to.
All right,
to,
well, let's see how we go.
Yes. Just go back to where I was. So it starts with in page 396 of the Medical Justice Bundle. It's internal page 9. So what it identifies is that notice of removal may be given in 3 different forms. So first of all, the first point is that of course the notice of removal window isn't mandated as the only way in which persons can be removed. Clearly, the Secretary of State acknowledges that she can give notice of removal directions, and that there's also the limited notice of removal. And this is also, perhaps in a way, the only reason I've not taken you back to the tribunal judgment is that they set out the way the policy operates very helpfully. And I'll just give you the paragraph numbers from paragraph 10. But of course, they were looking at version 15, so I've decided not to take the court back to their consideration of the policy. But in there, so we can see that notice of removal 3 different forms. And then there's only one of the forms is necessary in each case. So the enforcement officer may have discretion as to which of the above forms the notice is considered suitable. other cases, removal may be only possible with one form of notice, and we know what the Secretary of State says in relation to that. And it also expressly refers there under on the same page under notice of removal window to under this form of notice the person is given notice of removal window during which the removal may proceed without further notice. This form of notice is suitable for the following persons subject to exceptions. Persons being removed under section 10, the person will be given a notice of liability for removal, and then persons who are being deported. Again, it says, where a notice of liability for removal or deportation decision letter is given, it starts the notice period. The person may not be removed within this period. When the notice period ends, the removal window begins. A person may be removed during the removal window. And then the next, so that's absolutely clear in the sense of what the removal can take place without further notice. And the next sections all relate to how, when the notice period ends, whether the removal window could be extended, when it begins, when it expires, and so on. Of course, we recall that the Tribunal was concerned about some of those provisions were not earlier clear. So then just turning over the page to internal page 11, which should therefore be 398. It says the notice of liability for removal or deportation decision letter must include the place and country of return, and in relation to an asylum claim, details of a part of which of the country to which they will be returned. And then it also provides for the notice of liability for removal must be accompanied by a factual summary. And bottom of penultimate paragraph on that page, the notice of liability or the deportation decision must be copied to any legal representative where the Home Office has details of representatives actively involved in the case, or where that person asks for their representative to send a copy. If someone has been given a notice of removal window, they need not always be taken into detention overnight. So as we can see, the notice period is 72 hours. I don't see it there actually. Is 72 hours for a person in detention or 7 days for a person not in detention. I'll just find you that reference just in a moment. But importantly, you can see, as I emphasised in the earlier submissions, that this notice refers to notice of liability, not actual removal. Back to looking at what the definitions of those terms mean. And then if I just turn over the page, at page 399, the Secretary of State identifies that certain people aren't suitable for removal windows. So what she says, that's at those 3 bullet points, which is that family cases, someone who's the person who has no leave but has made a protection or human rights claim and has an appeal pending, or where the Home Office has evidence beyond, which is effectively they're an adult at risk beyond self-declaration. So, and when we come to the other document I'll take you to is the policy equality statement, just when we come to it briefly from the Home Office, because that sets out the justification for the policy, and also the justifications for those sorts of exceptions. And then under the next heading, notice of removal directions. For those persons who are not suitable for a removal window, they will be given notice of directions which will specify the date of departure. And then the penultimate passage on that page, persons being removed must be given adequate notice that removal has been scheduled. Where a person has been retained, notice should be given as soon as the directions have been set. The person who is being removed is not detained, but the removal is to report removal directions have not yet been set. They should be guided and given as much notice as possible after the arrest. So what's scenarios in which directions will be set and notice will be given. The Secretary of State in her policy is just effectively making provision for removal of certain types of case, including the FB scenario, which is the kind of the common, perhaps the common scenario in relation to someone who has had a previous claim determined and making fresh representations. So that is what we say is that the provisional policy there. The notice, there is also the provision for the limited notice of removal. That doesn't concern the applicant's case here, which is contract the notice period, contract the window from the 3 months to 21 days for particular operational reasons. I'm not going to take them to that. I think Mrs. Kilmore may take them to that part of the policy if necessary.
And then we have the notice period.
So the notice period is at the bottom of page 400. 7 calendar days at the point the person is, if the person is not detained. Otherwise, subject to certain exceptions, and it's the exceptions we'll come to in a moment. Otherwise, subject to certain exceptions, the notice period must be following the minimums, and then you have normal enforcement, 72 hours, at least 2 working days. Third country cases for cases where the decision is certified a claim, a minimum of 5 working days. And normal enforcement is where we are in the context of FP. Sorry, I just noticed the time. So sorry, I should have started.
No, I it felt as if you were coming to the end of this, and so I
can.
thought it best to let you.
If with the court's permission.
Attention please.
Well, that may.
Attention please. This is the Incident Control Officer. An evacuation is in progress in the Thomas More building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Well, normal business would be for me to suggest we start again at 2 o'clock.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Thomas More building. Do not enter this area until further notice. Your area is not affected. Please continue.